Your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
And how do you choose to go forward?
Pro se, please.
Okay.
Honor.
Even though the right term. Okay.
And there's no victim in this alleged crime. I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions.
Today, we're seeing something pretty strange in the courtroom. A man is trying to defend himself by using the same old sovereign citizen argument. If you're not familiar with sovereign citizens, they're people who believe they don't have to follow U.S. laws and often claim they're above the legal system. This guy is giving it a try, but it's not working. The judge isn't taking him seriously, and honestly, it's hard not to laugh at how ridiculous it all is. You can't really blame the judge for not giving in. How do you argue with reality when someone is so sure they're right, even though they're completely off base? The law isn't going to bend for made-up rules.
As to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, that language doesn't make any sense. So
No, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's in
I'm
all
not
caps,
a person. I am one of the people. Thank you.
Okay. Thank you. All right. So for the record, that's my finding. Hey, hold on. We're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was.
It's honestly mind-blowing that we've reached a point where people believe their own delusions are true. Sovereign citizens have been a problem for a while, but this is a perfect example of why courts just don't entertain these arguments. It's frustrating to see that these ideas still have a hold on some people. What do you think? How do you feel about sovereign citizen claims? Drop your thoughts in the comments below. After watching this, it honestly feels like this guy's IQ is somewhere between room temperature and freezing. Things get even crazier when we meet a guy named PTO Ansley John Milton. Yep, he's another one of those sovereign citizen types, claiming that he's not a person but one of the people. This is the kind of logic they try to use, saying they don't have to follow US laws because they've made up their own rules. The judge isn't buying it, though, and makes it clear that this isn't how things work in a courtroom. After that strange back and forth, they finally get to the actual case at hand, the police officer's testimony.
Here. Officer advised Mr. Milton that he'd be trespassed from 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to articulate anything?
I'll let you know. So sit
Appreciate
tight.
it.
I'm still working through the process. Thank you.
Of course.
All right. So, Mr. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay,
Honor.
you know the right term, okay?
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cam.
Milton's arrest happened after he caused a scene at a 7-Eleven. He was drunk and disturbing the staff, who described him as a 5 feet 5 inches white man with a beard, wearing a green flannel. He was being belligerent and refused to leave when asked. When the police arrived, Milton went back to his Toyota 4Runner parked outside the store. The staff was uncomfortable and asked the officer to trespass him. The officer made contact and found out that Milton was a local homeless man who lived in his car. The officer had dealt with him before, and when asked if he had been inside the store, Milton admitted it. Then, he made the bizarre claim that he was too drunk to be held accountable. Of all the excuses to give when getting arrested, he just flat out admitted to the crime but tried to avoid responsibility by saying he was too intoxicated to face the consequences. What's crazy is that this is a typical sovereign citizen move. They think if they say enough ridiculous things, the law won't apply to them.
Like I said, I can't represent you. You're going to have to figure all that out yourself. For purposes of today,
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights?
Did I read my form? I don't believe I was provided anything.
Okay, is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
I know. All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so what the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. Okay. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Anything else?
That's it for now.
Okay.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Using "I'm too drunk" as an excuse after committing a crime is wild. It's like these people feel that no matter what they do, they're always in the right. Anyway, back to the story. The officer told Milton he'd be trespassed from the store, and Milton said he understood. He even offered to push his car out of the lot since he was too intoxicated to drive. The officer agreed and gave him until nightfall to move the vehicle. At this point, you're watching and thinking, how is this still happening? After being told he was trespassed and couldn't come back, Milton tried his luck again. This time, he asked the officer if he could go back in and charge his phone. Of course, the officer told him no and made it clear that if Milton tried to go inside again, he'd be arrested. The officer handed him a trespass notice, thinking that would be the end of it. But nope. About an hour later, the staff called the police again. Milton was back inside the 7-Eleven. This time, he repeated his now famous line, "I'm too drunk to be held accountable." When they called dispatch, he left again, but not before.
Which is one of the reasons you don't want to represent yourself, but, I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. Seem like a sharp guy, so.
Appreciate you, Your Honor.
Seem dedicated to it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store No criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
You know, if the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want from you. So just, I don't
Cool.
know whether
Well,
that
I have
changes anything.
$100. Isn't that
Okay, all right. I will set this for 3 weeks from today at 1:30 in the afternoon, so on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it, but they will be contacting you to give you whatever offer they have. And then you'll tell them, the court at that time, whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
awesome? In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail, so you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
Speaking
they've
of,
heard
by
you,
the way,
and Mr. Sharp has heard you, and we'll go forward that
on
way.
a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal, and I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So,
All right, we got that.
Yep, appreciate you.
The officer tracks Milton down again, and sure enough, he's still sticking to the same excuse. The officer notes that Milton is clearly drunk but still functional, meaning he understands what's happening. With that, the officer arrests Milton for criminal trespass and takes him to the county jail. Now we shift to the courtroom. The city is pushing to revoke Milton's deferred sentence for an earlier assault charge, arguing that this new violation should count against him. The judge asks if he has anything to say, but Milton doesn't seem concerned. Instead, he insists on representing himself in court, which he has the right to do. However, the judge is worried. She asks if he knows what he's getting into, given that he's clearly not a lawyer. When asked about his qualifications, Milton pulls a classic sovereign citizen move and refuses to confirm whether he's ever been to law school. This tells everyone how seriously he's taking this. The judge makes it clear that if Milton insists on representing himself, the court won't be able to help him. Basically, he'll be on his own. She stresses that if Milton chooses to represent himself, he's setting himself up for failure. Since he's not a lawyer, he's likely to miss key steps and make mistakes, which could hurt his case. She also points out that if an attorney tried to do the same thing, she'd advise them against it, because it's not a smart move. But since Milton has the right to represent himself, the judge just wants to make sure he fully understands the consequences.